You can buy land on a reservation if it's what they call fee land. In other words, it's privately owned land. You can also buy land if it's trust land if you are an enrolled member of the tribe. Me, for example, would be unable to purchase land that's in trust status. And that harkens back to the problem or the question of what are the tribal rights and tribal members' rights with the federal government as an Indian trust. Because an average non-Indian person can't own trust lands on the reservation, so I wouldn't be able to purchase them from another member, even if you wanted to sell, as only the Bureau of Indian Affairs can approve such a transaction. If the sale is to a non-Indian person, the BIA will rarely, if ever, approve such a sale. Any sale done without the BIA approval is void. On the reservation, there are three sets of laws that apply. There's the tribal code, generally has priority, but in many areas, federal law will apply. State law has no application on the reservations in this state. That may not be true in other states. But in this state, the only way for state law to have any effect on a particular tribal member within the reservation is if the tribe has passed some of their own ordinances which say expressly that we adopt South Dakota law. Otherwise, it stops at the border. The question of how do I know what laws apply is as difficult as a jurisdictional question. It depends on what is the situation, what were the facts that we're dealing with. It depends on who I am in terms of whether I am an enrolled member of that particular tribe, whether I'm an Indian at all, or whether I am a non-Indian person. If it's a totally Indian group of people, well, then the tribal law will almost always control. The Indian Child Welfare Act was imposed by Congress to try to correct a problem of too many Indian children who were needing protection because of a bad home life, where they were just being taken from tribal members and in many cases not even permitted to go to other tribal members. So the foster care system was taking Indian children from not only their parents or guardians, but from the reservation setting. The Indian Child Welfare Act, or ICWA, was established to try and establish a priority that first you should look to tribal members on the reservation as guardians if for some reason the parents aren't able to do so. It has no application as between parents, and that becomes a confusing thing in this day and age where many children are born out of wedlock, whether it's on the reservation or off the reservation. And people think that it should apply, especially if there's an enrolled member parent and a non-enrolled parent. It just simply has no application. Costello Porter has been practicing the ICWA law since it was established decades ago, both on the reservation and in state courts, and many times it falls to us to instruct the state courts on how the ICWA law should apply to an Indian in a particular situation, and remind the courts in the state or the federal system that tribal courts actually have something to say about it. If a person wants to have a business or conduct business on the reservation, you need a lawyer who's familiar with the laws on the reservation. In our case, Costello Porter has assisted businesses for almost 125 years on the reservation in getting things established. There is a business code that is in effect on many, though not all of the reservations. Many of the reservations now have their equivalent of a uniform commercial code. They have business license provisions. They also have an employment rights office that too many employers seem to ignore, or they're just simply unaware of it. But like any other jurisdiction, if you go to another state or another country, you need to apply their laws.